Running a child care program can be a great way to help children and families in your community, as well as a very rewarding profession. You watch children grow and develop and share advice with families. It can be fulfilling and exciting to work with children and families. But remember that running a child care program is a business. The first thing to consider when thinking about running your own child care program is whether or not your plans must include licensure or registration with the Office of Children and Family Services. There are laws that guide the licensing and registration requirement. You must be licensed or registered as a family daycare, group family daycare, or daycare center if your plans include caring for 3 or more non-relative children away from the child's home for 3 or more hours a day per child. These guidelines are based on social services law. Social services law helps us understand the definition of child care to be caring for a child on a regular basis provided away from the child's residence for less than 24 hours per day by someone other than the parent, step-parent, guardian, or relative within the 3rd degree of consanguinity of the parents or step-parents of such child. A relative is a person who is within the 3rd degree of consanguinity of the parent or step-parent. Now, some of you might not hear the term consanguinity every day. Consanguinity is defined as relationship by descent from a common ancestor or kinship. It's also defined as a close relationship or connection. This means that in order for the provider to be considered a relative, they must be one of the following: the grandparent of the child, the great-grandparent of the child, the great-great-grandparent of the child, the aunt or uncle of the child, including the spouse of the aunt or uncle, the great-aunt and great-uncle of the child, including the spouse of the great-aunt and great-uncle, the sibling of the child, or the first cousin of the child, including the spouse of the first cousin. Let's take a look at what 3 hours per day per child actually means. Caring for a child for more than 3 hours per day per child means that the individual children must be present for more than 3 hours a day. It does not matter how many hours a day the program operates. The per-child language means how many hours a day particular children receive care, and so children who receive care for no more than 3 hours a day are not considered in determining if the program is required to be licensed or registered. A school-age program is defined as a program or facility which is not a residence in which child daycare is provided to an enrolled group of 7 or more children under 13 years of age during the school year before and or after the period such children are ordinarily in school or during school lunch periods. School-age childcare programs also may provide care during school holidays and those periods of the year in which school is not in session, including summer vacation. Such programs must operate consistent with the local school calendar. The name, description, or form of the entity which operates a school-age childcare program does not affect its status as a school-age childcare program. If you don't plan to operate a school-age childcare program, continue on with the training. If you are planning on running a school-age childcare program, please move on to watch the school-age section of this orientation.